उसका वीडियो बंद करो उसका वीडियो बंद करो उसका Thank you very much, Dr. Rakesh, sir. I hope everyone can hear me. Thank you, Dr. Rakesh, sir. Hope my voice is clear. Hope my voice is clear. Okay. Thank you very much. So I just want to share my screen. Right. So is it visible? All right. So good evening, everyone. Today we are going to understand the intellectual property. Commonly, it is called as intellectual property. So it is my pleasure to deliver such a type of innovative session on IPR awareness and opportunity towards innovation. Uh, I'm very much thankful to Ashwin sir, Dr. Ashwin sir, and Dr. Veena Santosh madam, and all the organizer. So, good evening, everyone. Today, we are going to understand this particular concept. This session will cover what exactly mean by intellectual property, who can create intellectual property, why it is important, type of intellectual property, and how it can be filed, what is a patent, what is trademark, what is copyright, and what is design. Because this particular IPR is classified in four category, that is patent, trademark, copyright, and design. Before that, I just want to ask you the difference between project, prototype, and a product. So you can see here, if we can design any type of project. Okay. So in the today, yes, sir. What exactly? Yeah. Just okay. That's fine. Now is it right? Right. No issue, no issue, no issue. Please, thank you very much. So today's innovation is not limited to the industries. It will start in the classroom. It may be in the laboratories, projects, startups, and research project itself. Intellectual property ensure our innovation students can recognize or a researcher can recognize by their own work, protection of their work, and benefits from the other like agencies. So what is the difference between project, prototype model, and a product? So you can see here, if I can going to design any project, then this is simply a like a hardware or a model which can just summarize their concepts or an idea. But if I can go for a prototype model, then it should be a part of sort of any model which can deliver your idea, and then it can convert into a product. So these are the three categories. In these three categories we can design a patent. Okay, that is simply a patent. So IPR is a legal system created by a government of India. It protects idea once they take a tangible form. Tangible form, it means it should be a market based system. So as we see, a patent, trademark, copyright, design, I can say that create a prototype model with an original concept. Whenever you have any idea, you have to convert in that particular idea in a project. Then that idea should be in the form of a prototype model. And as per the requirement of a market, you have to convert that particular prototype model in a original product. So you will receive a recognition and benefits from of your hard work. It cannot be copied. People who can try to copy your concepts, it cannot be copied. So like I can say that you have to work on your product, and then you can convert that particular product in a like particular product project. So what is intellectual property? First of all, you have to identify a problem statement. There are numerous companies, those who have their problem statement. You can see a Smart India hackathon. There are numerous problems by government of India. There are numerous problems by multinational companies. There are numerous problems by different agencies. So whenever you create something new, we want to recognition, protection, intellectual property, ensure that original creators get credit and benefits. It prevents other from the copying or misusing that invention. And an unfair financial gain also be there. So when a many students make a project, it helps identify a original idea. So if you have a problem statement, you have to convert that particular problem statement as per the requirement of society or a social change. What exactly mean by that particular intellectual property? So the type of intangible property, it cannot be a like touch or seen. We can say that it is also categorized as per the territorial restriction, as per the country itself, or as per the territorial condition itself. We cannot develop a product here itself and file a patent in a other country. You have to file here, you have to develop here, and you have to publish here itself. A product developed by a person is most important. An idea that takes actual from a prototype model or a product or a work. This is a basic definition of an intellectual property. Now, the question is why it is called as intellectual property. And because it's from a person intellectual ideas, and property because it can be sellable, you can sell it out as per the requirement of a market, so that's why it is a property. So it is a financial gain, that's why it is called as intellectual property. Now I can say that the offices of a controller general of patent, design and trademark, as I already mentioned in the previous slides, there are four categories. One is a patent, second is a design, then trademark, and a copyright. So as you see here, there are a patent office in a Kolkata, that is a head office in India, then Delhi, then Chennai, and then Mumbai. This is the territory. Then we have a design office in a Kolkata, trademark office. What is trademark, that we will see in the next slide itself. What is design, that also we will see in the next slides. The head office of a trademark is in Mumbai. Then there are multiple offices: Delhi, Kolkata, Chennai, Ahmedabad. Then we have a copyright. We are categorized four different categories: patent, design patent, trademark, and copyright. So we are talking about this particular four categories, and there are multiple two or more categories. So copyright head office is in Delhi. So territory of or the jurisdiction of this particular patent office. So patent office branch in Delhi, the state of Andhra Pradesh territory under this particular Chennai office is state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu. It means you can say that if I am belongs to a Maharashtra, so the my patent office branch is Mumbai. I have to apply my patent or I have to file my patent in the Mumbai branch itself, because I am belongs to the territory of Mumbai, Maharashtra, Gujarat, Madhya Pradesh, Goa. These states can apply their particular this particular state can apply their patent under the Mumbai office. After applying this particular patent or filing this patent in a Mumbai office, then there are multiple stages that we will see in that particular upcoming slide itself. So there, these are the offices, four offices: Chennai, Mumbai, Delhi, and Kolkata for the patent jurisdiction. Then, who can file a patent application? In India, there are multiple sections for filing or a process of filing. Section 6 and Section 134. There are multiple sections that we will see in upcoming slide itself. The application can be filed either alone or jointly or through a particular entity or organization by any person claiming to be a true and a first inventor. As you are an inventor, then you can file a patent. It is not required to like develop a particular idea, or we can say that prototype model. If you have idea, you can file a patent. If you have a prototype model, you can file a patent. So there are multiple stages that we will see in the upcoming slides itself. So the appropriate office of the patent office shall be head office of the patent, residential of applicant or domicile or a place of business, are a particularly territorial limitation, the place where the invention actually originated. So where to file a patent application, so we can file as per your territory. So on the basis of your state or a territory, you can file that particular patent, apply in that particular patent office itself. I can say that who can create an intellectual property? I can say everyone. There is no age limitation. There is no, particularly we can say that like there is no sort of education limitation itself. So any person, those who have an idea or a human intelligence idea that can create or that can apply that particular idea, intelligence, creativity, skills are a factor. There is no factor of an education. You don't need a degree or innovation, only originality of that particular patent it required. You can see there are numerous examples on a screen. Six player circular chessboard is one of the innovation that can be patentable. 25,000 painting by age 7 is again a part of patentable. We can say that wrote Nanne Pankho Ki Udan wordings claiming on that particular poet, it's again a part of patentable. Invented a new broom is again a part of patentable. So these are the different example, and that can be developed by a person itself. So you can also file. I can say, if anybody who would you feel it someone copied your poem without your permission and got praised by a teacher, how you feel? I can say it can be a crime, or it can be a particularly we can say that it is not a good way to copy anything from any particular person. So IP protect invention, help creator earn reward, strengthening the economy. We can say that it improve the design and usefulness of everybody. So children writing book, inventing a product, creating an art. As per the NEP 2020 innovation mindset, it required a patentable protection. There are multiple examples or research plagiarism or startup, or like we can say that brand misuse. There are multiple we can observe in a market itself. So this is like we can say it's not good way to like theft some sort of idea or a patent or any sort of innovation. So I can say an innovation brings an idea as a product, or as a project, or as a prototype model, or as an idea. Once an idea or prototype model becomes an actual product, you can start to file that particular uh, patent. Apply the government for the patent to protect the product. A patent, we can say that you can get a 20 years by your own name, after which your invention becomes free of anyone to use. During this 20 years, you can give a license and ask for a fee from those who wants to use this particular invention. So this is a magic of a patent. I can say that what can be patented? An invention and not a discovery. If you have an invention, then you can file a patent. Patent invention, trademark, brand in identity, copyright, creative works, design, visual appearance. So this R can be a patentable. New useful industrial applicable can also be a patentable. Discoveries or medical treatment cannot be a patentable. I can say that sometimes that a new or novel, for example, square wheel instead of round wheel. We know that cycle we have, bicycle we have, but if it is a square wheel, then it can be an invention. We can file a particular claim itself. Sometimes that can be used, that can be made in industry or on a commercial scale. But I can say that a doctor cannot patent a method of treating a patient itself. So These are the examples. You will get a licensing, royalty income, startup creation, or you can say that uh, you'll get a particular benefit itself. So it is get classified. We can say patent can classify in a different categories. One is idea patent. If you have an idea, you can classify that particular idea. You can draft that as per the act and then convert into the form of patent. Then we have a process patent. There are multiple, like we can say that device or particularly any product, it have a process. So we can file a process patent itself. Then we have a product patent. So invention or discovery that can be converted into the product. So you can file that particular product before it's available in the market. You have to file that particular product as an a patent. So there are multiple acts. You can see here that multiple acts. We can say that in a year of 1856, Act of 1856 to protection of invention. 1911 Indian Patent Acts, Design Acts. It get categorized into part. One is nothing but the Indian Patent and Design Act itself. In the 1970, Patent Acts only process patent, 14 years for a process patent and 7 years for the food and drugs. In the 1999, Indian signed TRIPS, process and protect patents categorized in two categories. In the year of 1999, 2000 and 2004, amended for the efficiency of the Act. And in the year of 2005, Indian Patent Acts process patent and protect patent for the year of 20 years. So these are the acts and these are the standards acts. And from the year of 2004 and 2005, you'll get a sort of category of a patent. So categories are utility patent. You can say that you invent or a discovery any new and useful process, machine, article of manufacture or composition of matter or any new useful improvement can be a utility patent. For example, machine, example, a camera, article or manufacture, for example, carpet, again and patentable, composition of a matter, again and patentable. So adhesive are an example of a patentable. So these are category of utility patent. You can say that a design patent, invent new, original and ornamental design for the article of manufacture. This can be a patentable. Design patent, for example, a shoe, Puma shoes have their own design patent. For example, you have a cello bottle that they have their own patent and design patent. So ornament, any type of ornament, jewelries are a part of a design patent. So this is the part of a design patent. So third is nothing but a plant patent, invent or discover any asexually reproduce any distinct and a new variety of a plant. For example, we know hybrid rose plant with a novel color, again a patentable. So these are the three categories. As I already mentioned, first is utility patent, second is a design patent, and third one is nothing but a plant patent. These are the categories of a patent. Now, whenever you apply a patent, then there are categories. Stage one, first you have to file a patent. It in a two category. One is nothing but your provisional specification, and second is nothing but your complete specification. What exactly it is, we will see in the next slide itself. Second is nothing but a process of application, processing of application. Third stage is nothing but a publication. Whenever you will file a patent, then after certain period of time, it can be published in the journal of a patent. Then fourth stage is nothing but a submission of the request for the examination. Whenever you will publish your patent, during that process you have to file that particular patent for examination. Whenever it will be apply for the examination, then the next stage is nothing but a pre-grant opposition. It means FER. Okay, first examination report will get generated through a controller and an examiner. Whenever it will get generated that particular first examination report, you have to submit their answer within a 6 month of period that is mentioned in a first examination report. Then after that, there is a grant or a pre-grant opposition. It means hearing. And then after that, post-grant opposition. After granting that particular patent, you have to maintain a patent or maintenance of patent and publication in an original journal. So these are the 8 stages for applying of a patent. So these are the way. Pre 2005, there are categories or the stages are nothing but your patent application, then directly a examination, then application in a order for grant, and an advertisement of acceptance of complete specification. But after 2005, patent application first filing process, then publication, then pre-granting opposition. During that pre-granting opposition, there is examination. After examination, submitting a examination, then there will be a application in order for a grant. It means hearing. And after hearing, if that particular patent is properly drafted and available and as per the grant of market, then it will be grant, publication of a grant, and then we have to maintain. So before 2005, the process was different, and after 2005 the process is different. Now we follow the process after 2005. During this process, if you want to apply for a PCT, it means international publication. So after filing, in between the 12 month, you have to file a PCT application. Typically, a national patent application in the home country of the applicant is a filing process. After filing, you can file a PCT application. It means International Search Report and Written Opinion. After this particular process, you will get an international publication number, and on the basis of that, you will get international recognition. So this is a process. Previous process was a national level process, and during this particular process you can file a PCT application for the international publication itself. So for international publication you have to file a PCT application. You'll get a mail, or you can file by submitting the particular form for a PCT application. Now, as I see the filing of patent application, which type of form and the pro forma is required. First is nothing but a form number one, that is main application form. What exactly it is, that we will see. Second is nothing but a provisional or complete specification. Filing of complete specification after a provisional specification. Sometimes you have a result, you have complete draft, you with a particular original concept, then you can file a complete specification once. Form number three is a student statement and undertaking under section 8 as an inventor declaration application. Form number 5 is nothing but a declaration of to the inventorship. Form number 25 is a power of attorney if you will apply through agent itself. Sometimes you need a help from agent itself, so that time the agent will get file a form number 25. Form number 9 is a request for publication. So you can see here, form number 9 is for request for application. If you file form number 1, 2, 3, 5, and 9 only, it means your publication, your patent will get published only. After the filing of form number 18, then only you can submit a request for examination of application for a patent. After examination, then the process will get changed. So corresponding like as per the requirement, okay, pre publication process, then granting process, examination, that can be possible only after submitting form number 18 itself, and then corresponding application maintenance of patent. So these are the process. As per the process, which type of documents I required? Covering letter including a list of document, then application for grant of patent in a form number 1. It required section number 7, 54, and 135 and rule 21. That is a rule for the form number 1. Then complete or provisional specification in form number 2. Section 10, rule 13. Statement and undertaking in a form number 3. Section 8, rule 12. Power of attorney in a form number 26 in original. Rule 3.3a, if filed through the attorney itself, as I mentioned, if you will file through the attorney, then that this particular form 26 is required. Declaration of inventorship in a form number 5, only in case of Indian application, Rule 4.17. Certified true copy of priority documents in case of priority is claim, and requisite stationery fees, statutory fees. It means check or TD. That is somehow variable that we will see in the next upcoming slide itself. So, as I mentioned in a previous slide about the provisional specification. Hello. Okay. A provisional specification is usually filed to establish priority of invention in case of disclosed invention. Before disclosing your invention, you can just submit a provisional specification. But if you have a complete documentation or detailed invention where you have a result and complete outcome of that particular specification or a patent, then you can go for a complete specification which patent protection is desired and disclose whenever it is get completely specified. So these are the two way. First is provisional specification and second is complete specification. In a provisional specification, you have just a priority of invention. In a complete specification, you have a complete detailed result that can be possible. No patent is granted on the basis of provisional specification that you can observe. You can see if you will submit a provisional specification within the 18 month, you have to submit a complete specification. If you cannot submit a complete specification, then no patent is granted on the basis of provisional specification. So you have to submit a provisional specification as early as possible within the 18 month of period. Now, okay, so if you have any doubt, any question, you can ask all the like participant. If you have any doubt, please you can ask. Otherwise, you can proceed. You can ask. You can freely ask. Any question? Okay, please. What exactly it is? It cannot visible for me. Yes. Yeah, right. Okay. Hmm. No, see, this is I already mentioned that algorithms or mathematical formula that I will also mention in the upcoming slide itself. So that cannot be some sort of patentable. But if there is any process as per the outcome of that particular result, mathematical analysis cannot be some sort of patentable. So it's if that particular mathematical model is useful in application, and that application will get some sort of result, then sometimes it will be patentable, but simply a mathematical formula cannot be a patentable. Okay. Any- yeah, right. 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 Hmm. Yeah. See, Uh, as we don't have any sort of result, you can see the definition of provisional specification as provisional specification is usually filed to establish a priority of invention. Priority of invention in case of disclosed invention, it is only at a conceptual stage, only conceptual stage. As I have a flow chart, I can do such a type of invention is a concept. This is my concept. A delay is expected is in submitting full and specific description of the invention. For example, if you start to design or develop any idea, but that is a concept, only a concept in your mind. Okay, you cannot convert in a particular product or design any idea, or we can say that convert into the form of circuit or any sort of product. Before that, you have just idea, and you think that this idea is very innovative, and that innovative idea I have to patent. So that can be a provisional specification. But dear sir, that provisional specification cannot be a grant, can't be granted, because it required a complete specification. A result is most important. So it means during this particular 18-month of period, you have to start to work on that particular provisional specification. That a complete specification, as in a complete specification, is a document in which all the details of the invention for which patent protection is desired or disclosed. It means you have to concise or perfect result. So this is like provisional specification, a difference between provisional specification and complete specification. I think, are you clear? Yeah. Yes, yes, yes. Okay. Shall we proceed? Yeah, right. Hmm. Right, right. That I will show you in the next upcoming slide. That is good, question. But whatever is in your mind, so whenever you'll be a part of like UG student, as a UG students, everywhere we have to like submit a project. Am I right? Even though PG student itself, even though PhD student itself, everywhere we have to submit a project. So it means innovation. If you have to innovate this particular concept or idea, then after some certain period of time, if anybody will like create some sort of innovative thing on your project and submit as a patent, and after certain instant you can observe that, oh, this was my idea, but like that time I didn't file a patent. So it will recognize by that particular fellow, not you. So better to like complete whenever you'll go for a project or any idea or any concept. So first of all, before submitting anywhere or before publishing anywhere, if you think this is patentable idea, you can publish a patent first. Then you can go for a particularly publication and another thing. So this is that's why, as per my experience, when I started to work on my like ideas, so first of all, I like started to work on my patent as well parallelly on a product. So whenever the product is going on, parallelly my patent is also is going on. And after getting a complete result, first I started to file a patent itself. So that's why I got such type of recognition in a society. In a research itself, you can observe that there is an analysis in a paper publication or in a research publication. There is a simply analysis. You can submit an analysis of that particular research work and submit in Scopus or SCI. That is also innovation. That is also a good thing. But what is a recognition? You cannot sell that particular research in a market. You cannot submit that particular idea to the company. But patent you can submit as an like idea or a product to the market, to the company, and then it will get a financial benefit to you. So this is that's why I just want to go for a patent. I think, yeah, yeah, right. So shall we proceed? Yeah. So whenever you'll start to design any concept or any idea, so which type of drafting you require? First is a title of invention, then field of invention. Okay, there are multiple field, but you have to identify the field of invention, background of invention, prior art. Okay, then object of the invention that we will discuss in the upcoming slide itself. Summary of invention, then brief description of these are the titles and mandatory titles, and in that particular title you require a claim are classified in two category: independent claim and dependent claim. Dependent claim on the basis of your draft, okay, hardware and specification that you mention in your above complete specification. And then you have an abstract, not required in a provisional specification, claim, and abstract, but in a complete specification that required, because they need a result. Which type of hardware you use? For example, if I use a Raspberry Pi, previously in a prior art, someone already use a Node MCU. If I can compare, or if you can understand those who are belongs to electronics, so Raspberry Pi is an innovation than Node MCU. If I use some sort of open source, we can say that cloud. But if I create my own cloud, then again a claim. So these are the things we have to mention in a claim, and that can possible only when I have a result. So claim only in a complete specification, abstract only in a complete specification, not required in a provisional specification. Only a concept is required in a provisional specification. But if you file a provisional specification, then it cannot be a granted. So these are the titles. So as per the title, biological data, I can say that number and dates, application numbers and date, patent number and date, that is a biological information. Title of invention, we can say that a innovative title of invention you have to draft. Then name, there are three categories of names. One is the inventor name. Contributed in a claim invention may or may not have an owner or interest in a legal right itself. I can say that why it is called as contributed in claim invention, because you design, develop, create by your own, is a simple definition of inventor. Assignee, any organization or inventor have an ownership interest. For example, we can say that any college or any entity can be assignee, where you have developed your product. Then applicant name, organization or individual that files the patent application. Applicant, am I myself as an applicant as well as inventor. If you can see, there are numerous person in your patent, 10, 12, 15, 8, 2. Okay, you think so that you are only an inventor, then you can mention your name only in an inventor, as an inventor. You cannot mention other name as an inventor, because you will get a proper benefit when if you are an inventor. But if you are applicant as well as inventor, all are inventor and applicant, then you all are getting a proper benefit after granting, after commercialization of that particular patent. So these are the three categories mentioned in a name, and that can be mentioned in a form number 1, 2, 3, everywhere, every file. Then abstract, as I mentioned, as an abstract rule under section 17c, 137b, 137c and 137d of patent rule 2003, as an abstract rule. Okay, in depth you can go, but so because of time constraint we cannot. Background of an invention is under section 12.1. Then summary of invention, figure with the brief description that have their own rule. Detailed description in a specification or specification that have their own rule. Claim, as I mentioned, independent and dependent claim, refer sign with the rule 13.4 of the Patent Act 2003. So these are the rules and regulation for drafting a patent. Under this rule, if you file or draft a patent, then only it will be applicable for examination. Otherwise, there are numerous examination, like we can say that discrepancies mentioned by like we can say the controller or examiner, whenever you will file that particular patent during examination itself. So consciously file a patent under this section itself. So these are the section. Then I can go for patent protection and benefits. There are relative expenses to obtain. For example, initial filing process is 10,000 to 30,000. Then we have limitation, limited year of protection, 20 years from the filing date itself. And we know commercial benefits are there. So many commercial benefits are there. We can start your own startup itself. We can say that patent information, these are the things that we already discussed. We will skip this. As an example, we can see here Apple is having 7,000 patent. Okay, 7,000 patent. Apple holds a 7,000 patent, and these are the categories. You can see here: control of peripheral device technology, 3,088 patent; data processing technology, 452 patents; computer test technology 475 patents, programming or control technology 525 patents, computer input technology 1340 patents. So these are the patents. It means you can see one Apple product have different category of patent. One Apple product, different categories. Another example, again Apple has a greater more than 200 patents related to the multi-touch technology, only a multi-touch technology, how to hold, visualize indicator technologies, input technologies. You can see here which input technologies having 118 patents. Just imagine one product is having multiple patent. It means innovation never stop. You can start to identify a problem statement, you can start to design or develop and like create an idea, and you can go for their patent itself. So this just like funny example. We'll skip this. Now how do I register a patent? You can go for IP India sites, and you can go for process that I will show you that process itself. So this is like we'll skip this one. Okay. So, basic requirement, your system is having operating system, Windows XP, or like all these things. These are the process. We can go for a login first, then select entry, then enter details, save draft, and then go for a digital sign, the drafted entry itself. So what exactly it is that we will see. So this is a login process. Here we have to log in yourself. I can show you my login. So this screen is visible. This screen is visible. Can you?
Yes.
So you can see here the my wife name Achal Rahul Pethe is mentioned over here. This is sign out option. Okay, I just want to sign it out, and I can again login it here itself. So this is login process. Here I have login. That password is already there. Then this is all file, all form, new application. If I will click on a new application, then you can go for like e-processing. So proceed for e-filing. Then as I am, my jurisdiction is belongs to Maharashtra, so the jurisdiction is Mumbai. Then types of applicant, ordinary application. If you are a controller, if you are a divisional control application, divisional ordinary application. Okay, so but as an ordinary applicant, I'm going to select ordinary applicant. Then provisional specification and complete specification. So there are two way. Okay, if you have a result and everything, then you can go for a complete specification. Then number of pages, how many as per the description, how many like pages are there, number of claim. Okay, then number of pages of claim, then abstract pages, number of drawing, how many drawings do you have, then listing, sequence listing. Then you have to draft a title of invention, then address of corresponding, that by default my address is there, then state, then telephone number, email address. Okay, and here you have to draft like paste abstract, description and claim. After that you have to add applicant. If applicant and inventor are same, then you can click on this particular point, so the applicant and inventor will become same. And then after like selecting this particular tab, okay, you can submit form number 9, 18 and form number 28. If you are going to apply through any entity or through any organization, you have to click on form number 28. If you are not, then don't want to click, don't click on form number 28. Then after that form number 2, form number 9, form number 18, these are the forms are there. Okay, so these are the things which are a part. So we can go one by one. Okay, so you can see here, this is your login page. Okay, you can write it down your ID and password. Then after login, as you can select as a natural person or as an agent or as an authorized representative of a legal entity or small entity. Okay, then you can go for this particular process, a registration of a small entity or organization. Then user panel is looking like this, where you have your login name, applicant type, name, then address. All these things are available on a personal details. So as I already mentioned you, this is a login screen. Then this login screen will generate a complete registration entries. After completing registration entries, you can you will get a display like this. And if there is a part of sort of like any discrepancy, then you can cancel it, or certified view, or okay. Then as far as the user panel is concerned, so as I already show you this particular user panel, form number 1, 2, 9, 13, then 18, 28, you have to file one by one all these forms. These are the forms. Then after that, these forms you have to submit as per the requirement. Then form draft, digital signature, payment through gateway, and submission of transaction to the IPO server, and then you will receive a e-receipt. E-receipt as per the form, you will receive a e-receipt, means which type of form you have to submit. Each and every form have their own fees. Form number 1 is having 17,1750. Form number 18 is having 4,400. As per the form, it have their own particular fees. So you have to submit one by one each and every fees, or in a bulk itself, you can submit the fees itself. So these are the things. Okay, this is all the details you can say. After that, you have to submit the document. You can see here, upload your document, browse where you have to save in your PC itself, and submit one by one document. Claim, then complete specification, then abstract, then drawing. Then also it required a form number 1, 2, 5, as per the PDF format are concerned. So you can submit all the forms one by one and attach here itself. So this can be a process. And after that complete process, you can see your history of form. Whatever the form you already submitted, you can observe, or you can see on a tab, that is form history, drafted form, you can observe. And after that, this is all forms you can see here. Form number 1, then form number 5, form number 6, form number 13, form number 18. You can see all the form. If it is discarded, then you can see in a discarded option. If it is already drafted, then it is available in a already drafted format itself. After completing all the process, you have to submit a patent fees, okay, through a payment gateway. So UPI gateway and other things are there. Normally nationalized bank gateways are available. So you can select a particular bank details and you can submit your process, and it will generate acknowledgement slip. So this is your acknowledgement slip. And on the basis of that slip, you can see here form number 18 is having 4,000, form number 1 is having 1,600, form number 9 is having 2,500. These are the category of fees as per the form, and you will get this particular fees. So this is a filing process. After filing, it will get published, and after publication, it will get going for a first examination report. So these all these things are there. You can see the there are multiple sections. Section 6 to 11, I can say that who is eligible for patent. Then inventor assignee, legal representative. Section 7 is one invention for one application only. For section 7, proof of right is required as per the section 7. As per the section 7, required a complete specification or the provisional specification. Then section 8 is for foreign application, PCT application. Then section 9 is for provisional or complete specification through a section 9 itself. Then section 10 is complete specification, title, then methodologies, and all these things are related. Section 11A to 14 is for publication and examination or pre-grant application. Early publication are under section 11A to 14. Section 12 is for the within the 48 month you have to publish your patent. That is a part of your first examination report to generate under section 12. Then we can say that section 25 are we can say that section 25 are a part of entity, whatever the entity that we have. Okay, that can be possible by using section 25. So these are the complete sections. These are a part of your patent itself. Section 43 to 47, date of the publication. Section 45 is for filing and terms of the patent. Section 53 for 20 year itself. So these are the sections, and under this section you can observe the patent filing process itself. So through this all section you have to file your patent. If you cannot file under this section, you will not get you will not grant your patent itself. So as I see here, you can identify a process. First is application, then provisional specification. After provisional specification, there will be a complete specification. After complete specification, there will be examination. After examination, there will be a FER, that is first examination report. After FER, there will be application for publish. Application will become published. Then after FER and a publication, there is a pre-grant opposition, that is nothing but a granting process. And after this particular process, there is a grant of patent. And after granting, there is a post-grant opposition or a maintenance of patent. So this is a process. So during this process, step one is filing application, then step two is publication, step three is patent examination, step four is ready for objection, and step five is a patent granting process. So, which type of fees is required? That already we would have discussed. Priority date, prior art, FER, why examination is required, prior art search, how to search your patent through this particular link itself. You can go through this link, you'll get a particularly your patent or patentable idea that can be already available, we can say that it is available or not. You can identify through this particular link itself. So as I already discussed in the previous slides, there are category of patent, patent office, design patent, trademark, and all these things. If you can see here, like car, cloud, fossil, alarm clock, video games, out of which we can say which can be a patentable, which cannot be a patentable. So car can be a patentable. There are multiple innovations in a car itself. Then alarm clock is also patentable. Then fossil, it is not an invention because it's already existing in the nature. Cloud, it is not an invention because it's already existing in the nature. Video game, it can be patentable. So these are the examples which you can develop or design a patent in a future itself. Next is a trademark. If you have any doubt, any question, so you can ask. Otherwise, you can summarize a trademark and other detail itself in like within a few. Yeah. Any doubt? Any question? Okay. Yes, ma'am. Right. What happened whenever the students are going to develop a product or project? So they are going to submit their research work either in a conference or in any project exhibition or any sort of any competition. So I urge to everyone, before submitting your idea or before promoting your idea or before publishing your idea to someone else in front of someone else, you can go for a patent. This is first mistake. Because if as I know, I am aware about that patent, its ideas and everything. So what I can do, I can do, I can just understand your idea, I can just understand your concept, I can just listen everything from your end. I can just modify that particular idea, I can get some sort of innovation concepts in that particular idea, and I will patent it. What happened? As this is your original idea, but it cannot patented, and benefit get by someone else. Second point, whenever you're going for a particular any project, identify a problem statement by a industry. Okay, modify it, innovate it, and some sort of claims should be identified in that particular idea, and then submit, anyhow submit to the patent office. Third point, whenever you'll go for a particularly project, what happened, you like you have very into as an UG students or as an PG students or as an PhD students, and as per the rules and regulation, you don't have you don't have to submit a patent. You have to submit a research work itself. So you're going to submit some everywhere. You are going to submit in any sort of link itself. Don't go for this. First go for your patent itself, because if it is a patentable or if it is going to commercialize, then benefits is yours. Third point, don't send anything to anyone before patent. What happened? We can submit or send paper to anyone. You can submit or send any idea to the anyone. You can discuss anything to anyone. Don't do this. These are the mistakes. Not normally technical mistakes are, if you are going to file a patent, then you have to draft proper claim, dependent claim. It means your hardware, your concepts, what you are going to use in that particular hardware, and on the basis of that, independent claim. Okay, so sorry, independent claim is first one, and dependent claim on depend on a first claim. Okay, if I going to design any sort of idea, so there are multiple dependent claim on a idea itself, so you have to draft a dependent claim. So draft it and submit it without submitting a particular patent, or if you already submit to someone somewhere else, then you can think I am going for a patent. Then prior art will become they can they will give you an idea like this is already published, or this is already submitted, or this is already research work. So don't do that. Any further? Right. See, as you have an idea, then there is a tab, prior art search. You can see here. Is it visible? ipindia.nic.in. You can go and click on this particular link. Okay, you can search. There are multiple journals are there. Okay, and on the basis of that journal, you can identify your idea or correlate your idea with that particular previous submitted or previous patentable idea. And if it is a innovative one, or if it is a new one, then you can go for a patent, right? Okay. Yes, yes. Any other further question? Okay, so we can summarize. Yeah. uh, yes. Oh, right. Nice question. See, sir, uh, as we know that our curriculum or our systems follow a traditional way of education, that is syllabus based, paper based, question paper based. But whenever they will go for an interview, what happened that they require a skill. Which type of skills they require? They require practical skills. And whenever the interviewer ask a question, then they are like they cannot express their view in a practical way. They can express their view in a theoretical way. For example, I can say a C language, Fibonacci series, like addition, subtraction, multiplication, or in electronics way, I can say that like Arduino, then Node MCU, Raspberry Pi. Beyond that, company required beyond that. We don't have idea about that beyond the work is going on in the market. I can say that like company, power plant company, you can observe that commercial department, operation department, then quality department, then production department. There are numerous departments are there. Then fastener, then TLT, then we can say that like heat treatment department. Okay, so there are numerous department, but in a syllabus, such type of wordings are not mentioned. What happened whenever they are going and whenever they are going to develop a product or project, then they have a traditional way of thinking. They don't have a problem statement from a industry. So if we have a problem statement from an industry, we have a knowledge about the industry, we have a skill about the industry, then you can frame a product or a project as per the requirement of industry. This is the basic need, I think so. You can also observe as an like senior fellow, you can also observe whenever the students are going to face an interview, the interviewer ask about their final year project, and they are like they don't have any idea about that particular project itself. They develop as a product project, not an a product. So I urge everyone, just start to work on a product, not a project. Then they will get an idea, then they will know about which type of licensings are required, which type of commercialization rules and regulations are required to develop a product. They don't know. That is a mistake, and that is a part of NEP 2020. But still, there are numerous autonomous institutions, there are numerous universities are all now also follow a traditional way of education. I think practical way of education is most important. Then only the product based projects are going to develop. That is my urge. Sir, of course, as far as the mindset of faculties are concerned, uh, okay, we have to follow that particular traditional way. We have to teach a subject, we have to complete a syllabus, we have to complete a 6 units, we have to exams are there, like first semester exams, second semester exams, everything are there. That is fine, but simultaneously there is a one like concepts are there, internship, there is a one concept is project, there is a one point is mini projects. So I think every teacher or every university have to focus on a mini project, industry based, major project industry based, internship industry based. For that purpose we have some sort of a change in like traditional way. In a first year, second year, third year, we have to make some sort of syllabus as per the industry related. That is most important. Third, next point again, I have to observe whenever I as I am also a part of training and placement. Whenever students are going to face an interview, they cannot say a single word about their first question, that is tell me about yourself. That is one of the mistake, because they don't like what we follow traditional way. We didn't teach them to express their view in their first question, that is tell me about yourself. So what they required, they required a cut to cut answer on a cut to cut question. If it is possible, then the student will get selected. We observe one thing, some students are getting placed only on a one question, some students may not be placed after a numerous question, numerous questions they may ask to the students, because what they require a cut to cut answer. They thought, they thinks like that this particular fellow have a sort of skill, but they required a particular answer. If it is possible, then they will getting placed, and as per the requirement of company they required answer. So this is I think this is a particular point. Any question, if I'm not wrong, if all are agree with me. Right. Okay. So we can go for like we can summarize fast about trademark are nothing but a logo. Like it's Google, Geo. These are the logo. Then we can file a logo itself. Copyright, its original, literally or artistic work is a copyright. We can file at that copyright for 60 years. Then we have this is the login of copyright that already we know very well about that copyright. Design patent, this is a login of design patent. There are few forms to file a design patent. This is the process of design patent. And then we can like, go for a design patent like shoes, car, chair, pen, rocket, external body of rocket are a part of your design patent. So these are the things, these are the like we can say that as already discussed, patent, trademark, copyright, design. Okay, these are the certificates of patent, trademarks certificate like this, then patent certificate, design certificate, and copyright certificate. I can say that be innovative, uh, be real, buy real, think outside the box, produce original work, These are the recaps that we already discussed in our session itself. uh, like protection of original work is most important, recognition and reward is most important, encourage innovation and research is most important, facilitating technology transfer is most important, interdisciplinary project is most important, attract funding and partnership is again most important, then economic benefits of to the institution because of patent itself it can possible, identify industry based problem statement. I always I always like encourage students to identify industry problem statement and provide a solution to them. So this is the era of innovation, this is the era of technology. So you can see here cup and like this is a particular innovation. Bookshelf, you can see here a person is sitting as on a chair. This is the bicycle, again an innovation. So these are the things that we will skip. These are my achievements. These all are my patents total till now 45, nearby 45 patents, drafted by my own, created by my own. Then even though my students, maximum students are involved with me, and they have their own patent itself right now. Four students are working with Sonam Wangchuk sir at Ladakh itself on iStupa project. Then few students are working with me right now on a solar cleaning system. That is a very innovative thing by Harsh, then Rushabh, and then Rohit itself. These are the students that they innovate. They are belongs to CSE branch, but they are doing the solar cleaning system, automated solar cleaning system, and that is patentable system, and that can be going selling right now in Nagpur city. These are my patent, appreciated by Nitinji Gadkari on my IPR Achievers Indian Book of Record. These are the few things that I did, and then going on with Sonam Wangchuk sir. These are my students: Venkat, Isha, and then Vishal, and Aryansh. Appreciated by we can say that Chief Minister of Maharashtra, appreciated by Shri Nitinji Gadkari during Vidarbha, Audyogik Vidarbha. This is the visit during ISRO headquarter, Bangalore. You can just scan this particular QR code and just submit your feedback. If you have any doubt, any question, you can also submit that particular question. You can just scan it, and if you have any doubt, you can ask right now. Thank you very much. And this is a complete process about the patent. If you have any doubt, any question, so you can ask, please. I think interdisciplinary is most important. As we see here, mechanical student, electrical students, electronic students can design a complete product. So whenever you'll go to arrange a project team, then you have one student from electrical, one student from mechanical, one student from so power plant. Power plant is having some sort of machinery, automation machinery, PLC's machineries. Okay, so that required electrical engineer, that required automation person belongs to electronics engineer, that required a mechanical person that they develop or design a product itself. So such type of combinations are there. Even though electronics engineer, basically electronics engineer have huge scope to design a new innovative idea or concepts. As I'm belongs to electronics engineer, even though mechanical engineer also having a good scope. As we see here in automobile sector, there are numerous combination: electronics engineering, mechanical engineering, electrical engineering. There are huge combinations. Chemical engineering also are there, biotechnology engineering are also there, aeronautical engineering are also there. So these are the combinations. Everywhere we have a scope. There is no any area where we can explore ourselves. You have a some sort of idea, you can just explore yourself. I think this is era. I don't think so that college or university or faculties are responsible for your future. Only you are the responsible person for your future. If you have an idea, you can go ahead. Never, no one will stop you. No one will stop your concept. No one will stop yourself. In a corporate itself, if you have a good brand, as in a brand, Amitabh Bachchan is a brand. Like we can say that Sachin Tendulkar is a brand. You can create your name as a brand. Then that particular employer or a company will like offer you a job as per your requirement. So everywhere we have a scope. Right. Right. Mm, Mobile is one of the big challenge. ChatGPT is one of the big challenge because see, in our era we have to read a book. Now also I have a like cupboard with a book itself, and like I have my own notes in from being 2003 and 2004 itself. I write it by my own. So that culture, and nowadays only we can click on any word or any statement we can click, the chat gpt will give the result. Even the coding itself, as I observed that the students cannot code by their own. Logical concepts, reasoning concepts, technical concepts, basic concepts. So that they don't have. What they have to like write a paper, they have to submit thesis, they have to just get a result. And I can say that I always ask students in my session itself, if we will offer them a 12th class physics subject, like they cannot again like write it down in the particular paper itself or answer sheet itself. Even though from first year, if we'll give them a paper from first year itself, they cannot. So this is a problem. And even though they don't want to innovate, they are like just mug up a concept, submit it, and then it is like simply get a answer sheet. I can say that degree is an entry pass. Nowadays, mechanical engineer is in a software company, TCS and other things. Like those who have skill, they are getting a job. Those who have a concepts or idea or everything, they are getting a job. If you have a skill, then you will get a market, you have a brand, you have a name, you have a fame only on the basis of your skill. That is my urge to everyone. Just improve your skill. Just like this is like era of innovation, please. Right. Okay, under what condition name or word get a trademark? See, logo will become a trademark. This name and or word, I'm not getting what exactly you mean to say. Under what conditions name or word get a trademark? Logo will become a trademark. Geo is a yeah. Sony is a logo, is a trademark. Then Geo is a logo. Google is a logo. Okay, you can design your own name, or you can see if you'll visit my website. This is Dr. rahulmpethe.com, and I always mention my logo. This is Rahul M. Pethe. Okay, designed and developed by my student Rohit and my team. So this is my logo. You can see here. I think is it visible? Yeah, right. Now is it visible? Yeah, it's already shared. Now is it visible? Right. So you can see all of my students. Okay, this is my complete profile. Okay, 45. These are my patents, professional services. Okay, these are the things you can, and that to design and develop by my. Okay, can you hear me? Can you hear me? I just want to show. Yeah, right. I'm trying, but it's not. Okay. Just wait. Just give me a second. I will rejoin. Will it be okay? Can you hear me now? Can you hear me? Right. So such a type of projects and such type of innovations are there. If you have if you have any doubt, anything, so you can start to work on it. Don't stop. Okay. Don't, like, we know that never give up are the concept. There are numerous stories and other things are there. If you can discuss with anyone, you can identify that, like, as we know that, there are numerous, like, innovators are there, we know, like, I can say कि अगर न्यूटन ने जो है एप्पल गिरा, इसका इनोवेशन किया नहीं रहता, तो फिर हमें ना, लाइक, एक इतना बड़ा साइंटिस्ट नहीं मिला रहता. सो यू कैन, देयर आर न्यूमरस स्टोरी. आई कैन से दैट, लाइक, जियो जब स्टार्ट हुआ था, लाइक इट वाज स्टार्टेड इन 2007. ओके, एंड लाइक दैट टाइम दे रिक्वायर्ड 1.50 lakhs crore investment, out of which 1.25 lakhs crore investment, like, through a loan itself from bank. And like, they have to spend that all these things for 11 years. Like, they are going to waste their money. Means, I can say that कोई और उनको बोलता है कि लाइक आप ये बैंक में रख के बहुत सारा पैसा कमा सकते थे, बट नो. लाइक, और हर पर्सन से उनका कमाई होने वाला था 200 और 300 रुपीज. ओके, बट आज अगर मैं देखता हूँ तो उनकी वर्थ कमाई जो है 2018 के आसपास, जो वर्थ कमाई थी उनकी 3 लाख करोड़ रुपीज के हिसाब से थी, जिसमें कि उनका, लाइक, बहुत सारे एसेट्स थे. आईपीएल, जियो सिनेमा, लाइक, these are the things. If you have a sort of like innovation or like idea or concept, then you can proceed. Otherwise, अगर आप बोलते हैं कि like मैं नहीं कर सकता, तो it is likely to be impossible. Like, that is your skill. If you have skill, then you have to like innovate yourself. Never stop, never stop. Like, yeah, please. Right, right. Agree, right? Why not? So, just want to share screen again. Is it visible? Okay. So, about the copyright, s- right. So, this is your login. Okay. Filing an application first, then e-filing application. You can go or click on e-filing application. Is it visible, ma'am? So after e-filing application, you'll click, and then you can submit all the details, whatever the details they required in that particular field. You have to submit. Okay. As if you are filing through any organization, then you have to submit no objection certificate. If you are not filing through any organization, there is no need of no objection certificate. Then whatever the work do you have, painting, photographs, even though website code, that can be copyrighted. Okay. These are the things, poem itself or any ppt presentation notes can be copyright. So that you have to submit through this particular portal. You can go for copyright.gov.in. Okay, you can create your own login. Okay, and you can proceed for that particular process itself. So this is your copyright.gov.in. This is a copyright link. Okay, and you can directly submit your concept. Okay, so I can just show you. So this is your copyright. This is my own login. Okay, this is my own login. You can see here. Is it visible, ma'am? Okay. Right. So whenever you click on this particular process, now you can observe how many copyrights applications are submitted till now, how many are registered till now. Okay, these are my registered copyright. This is the certificate tab. Here you can download your certificate. Total 8 copyrights till now I have. Then you can submit on e-filing. Okay, e-filing, then click on the copyright registration. Then this is a form. These are the steps: step 1, step 2, step 3, and step 4. Okay, so here you can write it down, your name, address, and pin code. Save as a party details. Okay, and then accept it and proceed for next step. Step 2, statement of particulars. Then statement of further particulars and payment details. Okay, so you can submit 500 rupees fees is there for copyright. You can submit all this process, and there is a tab to attachment. You can attach your like whatever the copyright material do you have, and you can submit it. Okay, then there will be a receipt. That receipt you can use. After that process, it will be we can say that submitted first. If there is any sort of, it is under scrutiny. If there is any discrepancy there, then it will be under re-scrutiny. Okay, after submitting or discrepancy, it will get register. So these are all are registered patent that I have. Okay, and you can download your certificate itself. Is that okay? Yeah, right, 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 right. No, 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 madam, no, no. Okay, whenever you will file like filing this application, that time only you have to submit your copyright detail. Whatever the document do you have, that you have to submit at that same time. Right, right. No, some sort of. For example, do you have a subject physics, and you have your own handwritten notes, that can be copyright. Okay, but you don't want to copy through any book as it is copyright through any a book, and you have to submit it. You had some sort of course, we can make some sort of changes, so it can be possible a copyright. Yeah, yeah, right. One question regarding trademark. I applied for a trademark 1 year before, but same marks is used by someone, okay, from other state. But my product is already in the market without a trademark. How? Okay, see, uh, if the similarity is there, then and it is already trademark by the government of India, then you have to make some sort of change in your logo itself, and you have to submit or resubmit. As you already submitted it, there were some sort of discrepancy in your application. You have to check. If you applied through agent, you have to contact to your agent. If already applied through by your own, then I think so you have to check your login or email. If there is any discrepancy already submitted by them, raised by them, then you have to submit that particular discrepancy result in a particular period that mentioned in that particular examination or discrepancy report. So if you have already submitted, then only you will get a sort of trademark logo. Otherwise, it is impossible. You have to make some changes in your logo and you and resubmit it. Yes, I'm audible. You are audible. Please. Right. Right. Agree. Right. So you have to file a complaint. So you have to file a complaint against them. Yeah, right. There is a some sort of like tab, pre-grant opposition. Okay, and you have to prove yourself as your particular logo is already being submitted previous than particular the opponent are there, and then you have to clarify yourself. You have to submit all the details. As far as the clarity is concerned, then only they will give you a solution or a particular result on your case itself. Otherwise, they have to suggest you. They will suggest you to make some changes. And I will also suggest you don't go in such type of discrepancy or cases, because you know that there will be no such type of result, because they already like got some that particular same as an a trademark. So I don't think so there will be some sort of solution. So you can submit contact to agent itself. Yeah, you can directly contact to agent. If you applied through agent, then you can directly contact to agent and ask them for raise a discrepancy on this particular topic. They will raise. They will apply. Right, right, right. Any other further question? Right, right, right. See, basically two different categories: design patent and the idea or the process or utility patent. So one category is idea, utility, or process. First category. Second category is a design. Design doesn't require any sort of hardware, circuitry, result, and other thing. Only a shape. For example, if I have, I can say that this is a like mobile case, outer case, clear, and this will protect my cameras and everything. So this is a part of your design pattern. Okay, so it, it doesn't it doesn't require any sort of you can say that hardware specifications and other things. It just require a shape or like sort of any shape specifications only, nothing else. So this is a one category. Second is nothing but your idea patent, process patent, or a product patent that require a result. Okay, that require a claim, that require application based result. Okay, then only it can be possible idea patent. It cannot possible without a result. It cannot possible idea patent. Design patent can be for example, I can say that this is a cello bottle. Okay, like this is a shape, I can hold it this one. Okay, and it can keep water hot water or cold water inside this. Hot water and cold water with a claim. For example, it can maintain a hot water for 8 hours. It a claim. It can be a claim. So what process I have to develop inside this particular bottle is idea, right? But a shape is not an we can say that idea. It is a simply particularly we can say that a design concept, nothing else. Like a remote holder, like this is a remote holder. Okay, it have a simply we can hold a remote, we can hold a remote. Okay, or so I can say that this is a design, this is simply a design. We can make some changes in this particular design, new design pattern is there. Okay, the outer look of this particular remote is again a design, but internal circuit or internal specifications are there, are a different way. We can say that case, okay, specs case are in a different manner, is a design. Okay, so these are the way we can develop a design pattern, and that cannot be a commercialized, that can be a submit as an design itself. Yes, yes. Any further question? So my YouTube link is also there. You can also go through my YouTube link. My website is there. My LinkedIn account is also there. If you have any doubt, any query, then you can ping me anytime. I'm very much thankful to the team IHE members, uh, Dr. Ashwin sir, Dr. Veena ma'am, and Dr. Rakesh sir, and all the dignitaries from IHE organization. And hope the audience are like, or the participants are getting good knowledge about this particular session. And in future, if you require any sort of help from my side, I'm always be there. Thank you very much. AI in the field of research. See, it's a easygoing process nowadays, as we already discussed about that Google Gemini. We already know about that. We can say that um, Chat GPT. These are the things are easily available. That is fine, but I think students have to make some sort of your own idea, and use AI concepts, use AI innovative ideas in their own project or product. AI is very good, but don't use it as like we can say that like mobile is a good one. There are two way to use a mobile. One is a bad way, how to handle it, how to use it, how to spend a time. And second is nothing but your useful process, useful gadget. So same thing is for AI. We can use it for a good purpose as well as for a bad purpose, but I urge everyone to go for a good purpose. Innovation is always there, innovation is always in the AI itself. There are numerous AI tools are there: image creator, video creator, text creator. Everything is available in AI tools. Okay, so you can just make some sort of innovative thing through AI, but don't use it as an non-useful things, or some sort of simply कि हमें सारी solutions मिल रहे हैं उस हिसाब से उसको यूज ना करें. That is like need. And very much drastic change happen in future, in a job itself, in innovation itself, in like technology itself, because of AI. So use it and grab the opportunity with the help of AI. Thank you very much. Thank you, Dr. Rakesh sir. Thank you, Ashwin sir.